What's going on? It's your boy Bartlett, man. Today is the best day of my life, man. Tomorrow is not promised. Go on and dig a little dance while they still playing your song. So today, we are going to dive off into these extended prison sentences. 'Cause, right here, bro, this is the quietest moment in the courtroom. Not because people are calm, but because reality just walked in. Up until this second, crime was a story, a hustle, a moment, a decision that felt fast. But sentencing is slow. It's measured. It's calculated in years, not emotions. This is the moment when time stops being slang and starts being a sentence. Everybody talks about the crime. Nobody talks about the time. Because once time enters the conversation, everything gets uncomfortable. Watch the faces. This is the first time some people realize they didn't just lose a case, they lost their years of their life. Let's dive in. Whoa, 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 whoa. Oh, I'm about to say.
Friday morning, as 28-year-old Eric Metzig was given 2 life sentences without the possibility of parole in the murder of his parents, which prosecutors say was premeditated.
All things being considered, Mr. Metzig, you are hereby sentenced to life in the Wisconsin State Prison System, and both sentences will be consecutive to each other.
Metzig was convicted on 2 counts of first-degree intentional homicide for shooting and killing his parents, David and Jan Metzig, at their Winnebago County home in 2023. Before learning his sentence, Eric was given a chance to speak.
My parents were causing me to be depressed, causing me to be mentally ill. Prescription medication that I did not want to take. Due to the antidepressant medication, I'm certain that if I had not been taking that, this never would have happened.
The prosecution was also given a chance to speak.
He initially pleaded not guilty by reason of mental illness or defect, a plea which was not supported by either doctor who examined him.
And 2 of Eric's own brothers also gave statements in favor of him getting the maximum sentence.
Eric is willing to murder our own parents and attempt to tarnish our father's reputation, the very people who cared for him and loved him the most. He is capable of harming anyone.
He planned this terrible act, attempted to conceal it, and denied responsibility until the evidence against him was overwhelming. Only then did he enter a no contest plea to avoid a trial.
In the end, Judge Gibbs agreed.
There's some victim blaming, some medication blaming, but very little remorse is being shown.
And in addition to Metzig's 2 life sentences, Judge Gibbs also ordered that he pay restitution to the victims' families. In this case, his own family. In Oshkosh, Noah Cornelius, NBC 26.
Justin Evans pretended to be a police officer. He used a fake badge to target his victims nearly 2 years ago. In December, a jury convicted him of kidnapping and rape. And this morning, he learned his punishment. But before that happened, the defendant had a few things to say.
And Fox 13's Gloria Gomez explains why Evans is now claiming he didn't get a fair trial.
Even at his sentencing, Justin Evans remained defiant.
It still was a conflict of interest.
Evans blames his conviction in December on his public defender's illness.
I do know I have the right to a healthy lawyer to be able to make cognitive decisions and using his professional judgment.
In August of 2021, prosecutors say Justin Evans was driving around Tampa with a fake police badge and lights.
The defendant pretended he was a police officer. He effectuated a traffic stop on a vehicle containing 3 women.
One of those women says Evans ordered her out of the car and arrested her.
He told me that I was under arrest because he found marijuana in the car.
She says Evans handcuffed her and put her in the back of his car. He then drove her to an apartment complex where he raped her. Additional charges were filed against Evans when another alleged victim came forward after reading media reports and recognizing his car. This time the crime was captured on surveillance video. Deputies say you see Evans driving a dark-colored Chevy Malibu, pretending to be a police officer, pulling over a woman near the corner of Brook Street North and Bush Boulevard East. The video shows him making her get out of the car and patting her down while her 7-year-old son was inside the car. He leaves a short time later. But it would be the charges against this victim that would seal Evan's fate. He was found guilty of sexual battery and kidnapping. The judge sentenced him to life in prison. Gomez, Fox 13 News.
The remaining charges on a separate case were dropped by prosecutors after Evans was given a life sentence of kidnapping and raping a door.
Notice something. The judge isn't angry. Most judges don't yell. They don't insult. They just read. And that calm voice makes it worse, bro. Because this isn't personal. This is procedure. The judge isn't mad at you. Time doesn't need emotion to destroy life. Time is neutral. Time is patient. Time always wins. That's why sentencing hits harder than an arrest. Arrests feel temporary. Courts feel negotiable. Sentencing is final. This is when people realize they weren't fighting the police. They were fighting math.
DoorDash driver at gunpoint last week, now once out of jail. Joseph Killens faces several charges after police say he sexually assaulted the victim during a late-night delivery. And now Killens is asking a Tampa judge to release him on bond. Fox 13's Gloria Gomez joins us live from
as to malice murder, with the jury having found the defendant guilty. Sentence of the court is life to serve in confinement without parole. As to count 2, felony murder, guilty. It's vacated by law due to the conviction on count 1. As to count 3, felony murder, disposition by the jury of guilty. It is also vacated
this is
by
the one who
law
left his
due
son
to
in the car.
conviction on count 1. As to count 4, cruelty to children in the first degree, the jury having found the defendant guilty, the sentence of the court is 20 years to serve in confinement. Consecutive to count 1, malice murder, life to serve in confinement without parole.
Right.
Count 5, cruelty to children in the second degree, the jury having found the defendant guilty, it will merge into count 4 as a matter of law. As to count 6, criminal attempt to commit a felony, to wit, sexual exploitation of children, with a disposition by the jury of guilty, the court imposes a sentence of 10 years to serve in confinement, consecutive to counts 1 and 4. As to count 7, dissemination of harmful material to minors, with the jury having found the defendant guilty, the court imposes a sentence of 12 months to serve in confinement, consecutive to counts 1, 4, and 6. And as to count 8, dissemination of harmful material to minors, the jury having found the defendant guilty, the court imposes a sentence of 12 months to serve in confinement, consecutive to counts 1, 4, and
a Georgia
6
prison right
and
now.
7.
Hey. What did she do? She already claimed.
Any further victim impact statements, Mr. Ringo?
No, Your Honor, thank you.
All right. That at this time, Ms. Cooper is adjudicated to be guilty of the offense of murder in the first degree in violation of Iowa Code Sections 701.7 and 707.2, Parent 1, Parent A, and judgment is...
Look at the emotions now. Shock, tears, anger, collapse. This is emotional intelligence arriving late to the scene. The skills that could have stopped this moment weren't taught when they mattered. Nobody taught pause before reacting. Think past the moment. Separate ego from survival. So emotions drove the car and logic never grabbed the wheel. Now logic is here, but it's sitting in a courtroom, watching years get assigned. Prison is full of people who felt right in the moment and understood the consequences. Too late.
Is entered accordingly. She is sentenced to life in prison without the possibility of parole. Her custody is placed with the director of the Division of Adult Corrections, temporary custody with the county sheriff.
Ms. Cooper shall pay victim restitution to the estate of Ryan Cooper in the amount of $150,000 as required by Iowa Code Section 910.3B, Parent 1. And Mr. Hawbaker, there was a supplemental restitution request to Crime Victim Services, I believe, in the amount of $14,944.76. Any objection to that?
No, Your Honor.
And should also make restitution in that amount to Crime Victim Compensation Program. Ms. Cooper shall also make restitution for court costs in the amount established by the clerk of court and restitution for court-appointed counsel fees. Are you requesting any fees, Mr. Hawbaker?
No, Your Honor.
With respect to Category B restitution, I've reviewed an affidavit that Mr. Hawbaker has. Mr. Engel, have you seen that?
I have, Your Honor. Yes.
Does the state have any objection to me making a decision based on Ms. Cooper's ability to pay Category B restitution based on my review of that affidavit?
No, Your Honor.
All right, well, having reviewed that affidavit, I will waive payment of Category B restitution in Ms. Cooper's case. As required by Chapter 81 of the Iowa Criminal Code, Ms. Cooper shall provide a DNA sample to the Department of Correctional Services for purposes of DNA profiling based on the nature of the offense, and as required by Iowa Code Section 811.1, there's no bail in this case. As far as the reasons for my sentence are concerned, the sentence imposes a mandatory sentence about which the court has no discretion. I will say, this was a senseless crime. Mr. Cooper was, by what I heard at trial and from the statements I heard today, a hardworking, kind, generous man who loved his children and his many friends. Ms. Cooper, your actions, whether you were the one who shot Mr. Cooper or whether as a result of aiding and abetting Houston Danker resulted in his death, they deprived your children of not only a father but of a mother. And I can't really state any more eloquently than was stated in the victim impact statements the broader impact it's had on Mr. Cooper's many friends and family. Ms. Cooper, I do need to inform you that you have a right to appeal this case to the Iowa Supreme Court. If you're unable to pay the cost of an appeal, you have the right to apply to this court for appointment of counsel and furnishing them any necessary transcripts of relevant proceedings. All is provided for in Iowa Criminal Code, Chapter 814. If you do want to appeal, you have to perfect your appeal by filing a written notice of appeal with the Tama County Clerk of Court no later than 30 days from today's date. Perfection of your appeal on that matter is jurisdictional. Failure to comply with the provisions set out in Iowa Criminal Code Chapter 814 would preclude you from your right to pursue an appeal. If you do want to appeal, you have to have a copy of your notice of appeal served on or delivered to the Iowa Attorney General.
37-year-old Demetrius Blackwell sat in court as if he had not a care in the world. He had nothing to say to the judge, but the judge had a lot to say to him.
You're a cold, calculating killer. You realize what you did? You killed a man for no reason at all. To make that simple for your compromised brain. You're gonna die in prison.
Last month, Blackwell was convicted of murdering 25-year-old NYPD detective Brian Moore and attempting to murder his partner in 2015. They were searching for burglary suspects in Queens Village. They noticed Blackwell fiddling with something on his waistband. When Moore asked him, "Have you got something?" he replied with, "Yeah, I got something," firing 3 shots, 2 of them hitting Moore in the head and face. Moore's mother spoke inside court of how her world has been turned upside down without her son.
My soul was abruptly severed from me, and I have been left raw and half dead. This is my life sentence without the chance of parole.
Blackwell's attorney still claims his client suffers from severe epilepsy, leaving his brain severely impaired. There were many statements from the defense.
It's not as if he shot him directly in the head.
That alone upsetting for Moore's family, the dozens of officers in court, and the judge.
Get his smirking face out of this court.
As soon as the judge said the words "life without parole," you could see the sadness yet sense of relief on Moore's mother's face. Outside the courthouse, his father had this to say.
If the New York State penal system had the death penalty, like I said, I would love to see this animal put down. To me, that would be true justice. And I understand this is the best that we could do, and I'm thankful for it. but Brian is still not with us.
Moore's fellow officers say the streets will be much safer without Blackwell. In Queens County Court, Aaron Logan, CBS 2.
This is a job that comes with a lot of tragedy. That's something that those of us who do it know. And frankly, in many cases are used to. But there are cases that stand out over the course of your career. This case stands out even among those. Because tragedy as a word doesn't really even touch what happened here and what this family and community has been through, what they will continue to go through every day when they wake up without Monique. And so with that, Judge, we'd ask that you impose the mandatory sentence in this case of life in prison without the possibility of parole.
All right, thank you, Ms. Starkey. All right, Ms. Gadd.
The defense has nothing to add. Thank you.
All right. Anything, does your client wish to make any statements? He certainly has a right to make a statement. I'm happy to hear anything he has to say, or you can choose not to make any statement.
Mr. Wiggins does not wish to make a statement at this time.
Okay, thank you.
That means one person on that jury felt enough sympathy, mercy for you that they decided that you did not deserve the death penalty. So for that, I don't have to make that decision. It's not something that I ever wanted to do or wished to do. But if there was ever a case that I've ever heard that 12 people would have decided that death was appropriate, this is probably it. But that's their decision. I believe wholeheartedly in the judicial system, and I believe that those 12 people made up their mind, and that sentence will be imposed on you. But I also agree with the victims in this case. This was the most selfish, self-centered, evil thing that I've ever heard. That you took the stand and you said that you did all of this for your son is ridiculous. Your son was in the house when this occurred. He was either in the room or within 65, 70 feet of when you shot his mother, shot his grandfather, and then waited 5 hours, by your own admission, to walk downstairs and beat his grandmother to death. In those 5 hours, you must have sat in that house with your son. He was there. It's 6 o'clock in the evening. He's not asleep. He's not locked in his room. You're sitting there with your son, with his dead mother, his dead grandfather, and a man who gave his life for those people. You sat there with him and went downstairs and finished off his grandmother. And you did that for your own selfish reasons. Maybe it was your age. Maybe it was that you felt that they had done something to you that you needed to get revenge for. But there was no remorse. Just saying you're sorry doesn't make it so. You're not sorry for what you did yet. Maybe someday you will be. You weren't sorry that day. You weren't sorry when you took the stand, and you're not sorry now. Your son will grow up without a mother, and without grandparents, and without a father, just as you did. But worse than you, he will grow up without a father because he will know that his father murdered his mother and murdered his grandparents. There's no worse life than that. Hopefully, with the love that he has from the Piles and the Browns and all the other family relatives that he has, he will learn to understand and be happy and learn the things about his mother that he did not know because you took her at such a young age of his. There's nothing worse than losing a parent at a young age, but to have them taken from you by your father, I can't imagine. So hopefully, some way, somehow, through the love of the family that he has here, he will grow up to be a healthy, happy, productive, hard-working, loving person. But that's not because of you. So to say that Tristan is your whole world, I don't believe that. I don't believe Tristan was your whole world. I believe that you did this because you were selfish. And based on the decision of the jury, I sentence you in count 1 and count 4 to life in prison without the possibility of parole. In counts 2 and 3, I sentence you to life without the possibility of parole. However, that's with a firearm, discharge, include charging death, which means hopefully that no matter what happens with the legislature, no matter what we decide on life or death in your case, you will never, ever be released from prison. Can you afford to hire an attorney for your appeal?
No, Your Honor.
All right, so at this point, I will appoint the public defender to represent you for appeal. State, is there any costs associated that you're asking me to impose?
Yes. It goes without saying this crime involved great violence. It involved a firearm. It involved vulnerable witnesses, victims who, again, had no time to react, no time to defend themselves. It involved planning. I don't think you could say it was sophistication or professionalism, but it certainly involved planning. When you load a gun, arm yourself with a gun, drive 10 or 15 minutes to an apartment complex, as we saw on video, his demeanor going up the elevator, his demeanor going down the elevator, that showed planning. And obviously he took advantage of a position of trust. There's clearly that she didn't know he had a key, but he took advantage of that. Now, there are certain factors that, as for mitigating factors under the rules of court, I don't find any. Zero. None. There are certain factors with the defendant that I am obligated to take a look at. I acknowledge he has no prior record. I acknowledge the fact that at the time of this killing, he was suffering substance abuse and had some mental health issues. But I reject the fact that his childhood contributed to this at all. I hear terrible childhoods day in and day out, and his was not ideal, but it wasn't what we hear in this particular.
Derek Groves was sentenced for the 2018 Mardi Gras murder of 2 men. The sentencing comes 2 months after he was found in Atlanta following that historic jailbreak from the Orleans Justice Center. Alyssa Curtis was at the DA's office today.
Derek Groves will spend the rest of his life in prison. Friday, he was sentenced to 2 consecutive life sentences plus an additional 100 years.
And if you remember that jailbreak footage that was running, the first person out the gate, the fastest one, the one out the longest, was Mr. Groves.
Months after he was captured in Atlanta and years after his legal process began, Derek Groves has finally been sentenced. Groves was convicted back in October of 2024 for killing 2 men on Mardi Gras Day in 2018. Jamar Robinson and Byron Jackson, 2 others, were injured.
I think the biggest shock for me is just how evil some people can be, and evil to the point of it's funny to you.
Groves was initially convicted in 2019, but a new law requiring a unanimous jury for felony cases sent it back to a courtroom. Then a mistrial and a deadlocked jury drew the process out even more. After his final conviction, logistical issues like a recused...
This is what I want to say, bro. Free is a word, not a feeling, bro. Listen to how people say free. Free my brother. He'll be home soon. Just to be it. But time doesn't move like slang, bro. Time moves like birthdays missed, funerals watched, kids growing without memory. This is the moment freedom stops being abstract, because freedom isn't a mindset. In this room, or any courtroom, it's a number. And when the number is high enough, hope starts negotiating with denial. Let's continue.
A convicted killer preparing to spend the rest of his life behind bars for the murder of a Lakeland police officer. A jury just recommending life in prison without the possibility of parole for Kyle Williams. Our Ryan Raish has been following this case from the very beginning. He's covering Polk County Live tonight with the very latest. Ryan?
Yeah, Brenda, right now, convicted cop killer Kyle Williams is headed back to his jail cell where he will remain until he's transported to his new permanent home, a state prison.
We, the jury, advise and recommend to the court that it impose a sentence of life imprisonment upon Kyle Devonta Williams.
Learning that the jury just saved his life, this 21-year-old convicted killer showed no signs of relief. Nothing. His siblings flashed a smile, and later his attorney acknowledged the small victory for the defense.
Anytime you save a client's life, that is something very important.
Just days earlier, the same jury found Williams guilty of premeditated murder in the shooting of Officer Arnolfo Crispin. In this phase of the trial, they had only two options to recommend to the judge: life or death.
We didn't expect the verdict to come out this way.
The Crispin family begged for the death penalty, calling it the only option for someone who murders an innocent cop of all people. Now they're trying to look at the positive, trying to find that closure, nearly 3 years in the making.
I think that my mom and dad and all of my brothers and sisters will bring that closure, will come to realize, you know what? He has no life from now on. He's going to be locked up forever.
It's been an emotional roller coaster for the Crispin family throughout this trial. A lot of ups and some downs, including the sentence handed down today. Coming up at 6 o'clock, what Crispin's former colleagues over the Lakeland Police Department.
When reviewing the sentencing factors as outlined under 292911 and 292912, my job as a judge here is to punish the offender, but also to make sure that the sentence should be proportionate and not demeaning to the seriousness of the offender's conduct and the impact on the victims, and consistent with other sentences with similar crimes. In looking at the seriousness, of course, the child's age and the suffering weigh heavily for this court as well. And so with respect to my sentencing, after taking in consideration all the matters before the court that are appropriate under the principles and purposes of sentencing, the court's going to impose the following sentence. Starting with count 2, as found guilty on count 2 of murder, it's a life with parole eligibility at 15 years. On count 3, the murder charge under the B section, it's life with parole eligibility at 15 years. And those are the maximum sentences that can be handed down on those two counts. On count 4, with respect to the Reagan-Toke sentencing guidelines, count 4 and count 8 are both felonies of the second-degree felonious assault. We also speak to count 5, which was the endangering children as a felony of the second degree. And then we speak to count 7 and 6. The state and I have agreed that I will move forward with count 7. Under count 7, under the Reagan-Toke sentencing guidelines on the attempted murder in count 7, the court's going to hand down the maximum sentence of 11 years as the minimum sentence to the indefinite sentence of 16 and a half years. Again, I've outlined the Reagan-Toke guidelines and the reporting requirements for post-release control that will be controlling on all other felonies of the second and first degree, this being the highest level. I've outlined the 5 provisions, as I noted for the record already. And then with respect to the count 4 and 8, the maximum sentence is 8 years. I'll hand down that sentence. Count 5, 8 years. Count 6, 11 years. Count 8, 8 years. And then as indicted, count 10, which would be a 6-month sentence on the misdemeanor charge. Regarding aggravated murder and finding the defendant guilty of aggravated murder by this jury, the court's going to hand down a sentence of life without parole. I'll run every other sentence concurrent to life without parole. Ms. Ellis, you'll be given credit to 509 days of the time that you've served. I'll order you in the custody of the sheriff to transport you to Marysville Correctional Facility. I'll also indicate that fines, fees, and court costs will be waived. with respect to this sentence. In addition to the verdict that has been handed down by this jury and the sentence that the court handed down, Ms. Ellis, you have a right to appeal both the sentence and the conviction in this case. You can do that by filing a notice of appeal with the clerk of courts within 30 days of this sentence. If you're unable to pay for the cost of an appeal, you have the right to appeal without payment of costs. If you're unable to obtain counsel for an appeal, I'll appoint counsel to represent you. If you're unable to pay the cost of documents necessary, they are provided to you without cost. You have a right to a notice of appeal filed timely on your behalf. And Ms. Ellis or counsel, do you wish to appeal both the sentence and the conviction handed down in this case?
Yes, Your Honor. No objection for the record and appoint counsel for the appeal.
I'll note your objection regarding my sentence, and knowing that she's unable to afford counsel, I'm going to appoint the public defender to represent her with respect to her appeal.
Emotional moments in court after a Miami Gardens man is sentenced in the shooting death of his best friend. The victim's mother, present as her son's killer, learned his fate.
I am broken. I will never be the same. He still get to see his mama. He still get to see his family. We gotta go to a graveyard.
Damn, bro.
They were both 16 then, playing video games, when one of them pulled out a gun and fired at his friend. Good evening, I'm Jim Barry.
And I'm Lauren Pastrana. CBS News Miami's Peter Dench is your reporter in downtown Miami. He joins us live with reaction from both sides. Peter?
Lauren and Jim, we can tell you the sentence in this case was not as stiff as loved ones of the victim had hoped for. It was 8 years in prison, followed by 8 years for probation. Now, the victim's mother wept in court.
I am broken. I will never be the same.
Surrounded by her loved ones in a Miami courtroom, Latoya Taylor speaks out about the loss of her 16-year-old son, Savion Littles.
I was in a dark place for 2 years. He still get to see his mama. He still get to see his family. We gotta go to a graveyard.
She also speaks about her son's best friend, 19-year-old Hazel Canty, who had pleaded guilty to manslaughter. Canty pointed a gun at Littles at a home and pulled the trigger on Mother's Day weekend in May of 2023. Taylor had told us how proud she was of her son, who had transferred from Miramar High School to American High School to play football.
For somebody to take his life at the age of 16, he ain't gonna be able to make it to prom. I ain't gonna be able to see him graduate. I'm empty.
In court, Canty apologized to Little's family.
I just want y'all to know that I'm sorry. And I wish I could make it cut it out.
Judge Christina Miranda said Canty was reckless and sentenced him to 8 years in prison, followed by 8 years probation.
Unfortunately for Mr. Canty, there is nothing he can do that's going to change that day or bring him back, except learn a lesson.
We spoke with Canty's mother.
Hopefully he learned from his mistakes. We love Savion. We never going to stop loving Savion. He just like us. So instead of me losing one, I lost two. One through death, and my other one is in jail now.
Dang.
He meant everything to our family. Savion was our life, and he's going to be missed. Every day I think about him. He was my first grandson.
Now, Canty's attorney told me he was satisfied with what happened in court. We also spoke with Savion's grandmother about the sentence. We'll have her reaction coming up in just 1 hour at 6. We are live in Miami. Peter Dench, CBS News, Miami.
One of the most significant moments in Dallas history could happen later on this week. So what's happening here? County commissioners are expected to exonerate a man who was convicted and then executed for a murder the county now says 70 years later that he did not commit. Our J.D. Miles tonight looking back at the case and how a broken justice system could have led to such a shameful chapter of our history.
Looking into his eyes on this film from inside a Dallas courtroom, you can only imagine what was going through the mind of Tommy Lee Walker. His unbroken stare into the camera appears to look for reason and fairness that too often didn't exist in 1956.
The said warden is hereby directed and commanded to pass and cause to be passed through the body of you, Tommy Lee Walker, a current of electricity of sufficient intensity.
Now this is a twist because he was innocent. I'm looking, he was innocent. and they executed him, and then now they're going to exonerate. Man, get the. I'm going to the next one.
Ms. Blair, what did you do to Stony Blair that makes you guilty of premeditated murder?
She raped my son. I intentionally killed her.
How did you do that?
Starting from the beginning, when I found out about what Stony was doing, it was 9 months later after finding out about Stephen. So for the whole 9 months we were in the house, she was still raping my child. I did not know that. When I first found out, after told me,
I remember this case.
I took a minute because I was not understanding.
She was different with her time.
You know,
she was like, hey, come on with the time. I did the crime. That's different right there. Let's go to the next one.
Josiah Hewley. I can't see him. Mr. Hewley, count 1, felony murder. I sentence you to life without the possibility of parole. Count 2, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 1. Count 3, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 2. Count 10, hijacking a motor vehicle. I sentence you to 20 years consecutive to count 3. Count 11, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 10. I'm
going to interrupt. If there's one thing these moments teach us, it's this. Every crime has time attached to it. Every crime has time attached to it. You got to start doing your jail time. Hey, man, let's go out and do 1, 2, 3. Hey, man, 1 carry 5 years, 1 carry 2 years. 2 carry 2, and 3 carry a life sentence. You got to start doing your math. It got to be second nature. It got to be second nature. I'm sorry. It got to be second nature. It got to be second nature. Every crime has time attached to it, whether it's spoken or not. You might as well start speaking it. And the smartest thing you can do is factor time into every decision before it shows up in the courtroom. Because when we get to the courtroom, it's too motherfucking late. Stay out of prison. Isn't about being scared, bro. It's about being smart. It's about emotional control, being louder than ego, critical thinking, being stronger than impulse. Freedom being valued more than image. Because the real flex is never hearing your sentence read out loud. The real win is watching these videos from the outside, nigga. And choosing right now to stay free. We'll conclude.
12, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 11. Count 13, possession of a firearm during the commission of a felony. I sentence you to 5 years consecutive to count 12. Count 14, violation of Street Gang Terrorism Prevention Act. I sentence you to 20 years consecutive to count 13. Count 15, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 14. Mr. Hewley, you have now been convicted of 15 felonies, 6 of which either merge or vacate as an operation of law, so you'll be sentenced on 9 felonies. I need to inform you that you have the right to seek post-judgment relief from your felony convictions by either filing a direct appeal to a higher appellate court or to file a motion for new trial. You have 30 days from the date I sign and file your sentence with the clerk, which should be tomorrow, to file a motion for new trial to any or all of the felony charges. Ms. Drake, will you be filing a motion for new trial?
Yes, ma'am, and I did explain to my client why my appointment would not or should not continue on this case, and I would ask the court to appoint him appellate counsel.
Right. Mr. Hewley, as Ms. Drake has probably explained to you, your appellate counsel will review everything, including Ms. Drake's representation of you, to make sure that all your appellate rights are pursued. You also have 4 years from the date your sentence is final with this court, which should be tomorrow, to file a habeas corpus. I will appoint an appellate attorney who will be in contact with you. Mr. Collins, count 1, excuse me. Count 1, which is felony murder, predicate act is aggravated assault. I sentence you to life without the possibility of parole. Count 2, which is violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 1. Count 3, violation of Street Gang and Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 2. Count 10, hijacking motor vehicle. I sentence you to 20 years consecutive to count 3. Count 11, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 10. Count 12, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 11. Possession of a firearm during the commission of a felony. I sentence you to 5 years consecutive to count 12. Count 14, violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 13. Count 15, which is a violation of Street Gang Terrorism and Prevention Act. I sentence you to 20 years consecutive to count 14. Mr. Collins, you have now been convicted of 15 felonies, but sentenced to 9 because 6 of them, by operation of law, either merge into the other.
A Kansas City teen will spend 20 years behind bars in the deadly shooting of 11-year-old Courtney Freeman. Ramori Roth was tried as an adult and pleaded guilty to second-degree murder.
KSHB 41's Kansas City reporter Alyssa Jackson has been following this story from the beginning. Today, she was in court for the final step in the case.
It's been almost 2 years, and this was a day in court that Courtney Freeman's family has been waiting for. Her youth was a constant reminder for the judge. And another sticking point, you have an 11-year-old victim and a defendant who was 16 at the time of the offense. Those are 2 futures that will never be the same. The next 20 years of Ramori Roth's life will be spent in prison for second-degree murder. With credit for time served, he'll get out in his mid-30s. Courtney's future ended the day he pulled the trigger, firing several shots inside of her home.
She would have been everything. She wanted to be a lawyer. She wanted to be an OBGYN.
Because the judge did not allow cameras in court, I can only describe the hearing.
A 20-year sentence for somebody that was 16 years old at the time of the offense is not common. For him to be certified as an adult necessarily is not common.
The state painted Courtney in a way that would compel the judge to see her youth. Roth followed, taking full accountability for a circumstance he said shouldn't have happened like it did.
It will forever mess with me because I seen it happen and I watched it.
Courtney's sister is both critical, wishing Roth would serve more time, and grateful for the work of the
Your Honor, first we'd like to start off by indicating to these families that we are sorry for their loss, that this is a tragedy. As the court's aware, Mr. Silver also has a family. He has a daughter, a mother, brothers, and he's a high school graduate. He graduated from Glenville, played football there. Your Honor, Throughout this process, he has maintained his innocence. We would ask the court respectfully to appoint appellate counsel. We'd ask the court to order the transcript at the state's expense. We'd ask the court to recognize that he's been incarcerated now throughout this process and that he's indigent. We'd ask the court to suspend any court costs. Your Honor, in addition, we would ask the court respectfully to run these counts concurrent and to give him an opportunity at parole. Parole would give an opportunity for him while he's in prison.
And it's proper to bring people to court so that justice can be done. And whatever that justice outcome is what it is based upon the evidence and the credibility of the witnesses. Go ahead.
You're done?
I am done.
So you do believe that we all have equal protection of the law?
I'm not answering your questions. I am
It's
listening.
constitutional, right?
I'm not answering your questions right now,
That's not
sir.
gonna be
I'm listening
good.
to your impact
It's not
statement.
gonna be good.
Your statement.
Okay.
It's not gonna be good. It's not gonna be good.
As I was
don't know
saying,
what you
the
said.
Ohio Rules of Professional Conduct, Rule 8.4, prosecutors are advised and required to refrain from dishonesty, fraud, deceit, or misrepresentation pertaining to the rule or the overall judicial system itself. Sure, you can subpoena somebody to come to court, but texting and threatening them to come to court on something they should be willing to come tell, we shouldn't have to do. We shouldn't have to do that. We shouldn't have to do that.
Mr. James, the witness that you're referring to, ended up crying on the stand.
Excuse me?
He was crying on the stand.
Who?
The witness that he had brought to court, had forced to bring Mr. Collins, who could not have known. And I'll just add on that Mr. Collins found what you had told him so depraved and so...
On Friday, and I immediately sent the entirety of all the text messages to him.
Carried out the executions of the two men, and when you saw the two women there, you decided, I'm not going to leave any witnesses. And even knowing that one visibly was pregnant and also pleaded with you, stating that she was pregnant, you decided to take both of their lives in order to hide your crime. You killed 4 people and an unborn baby. And the amount of shell casings that were found indicates the level of your resolve to make sure that they were dead and how many bullets were fired into their bodies. This is nothing short of a mass shooting. The sentence will be as follows. For counts 1, 3, 7, 9, and 10, for the aggravated murder of Dejan Willis, Christopher Monroe, Ayanna Quitman, Jasmine Lawson, and Jasmine Lawson's unborn, I'm ordering a sentence of life without the possibility of parole. For count 16, I'm aggravated burglary, 10 years in prison. Count 28, the attempted murder of Mr. Reuben James, that's 11 years in prison. For the having weapons on your disability, as I previously stated, this is 2 additional times that you have used and had a gun. That's 36 months for each of those counts. For counts 1, 7, and 28, I am imposing the 54-month firearm specifications. Those will all run consecutive to one another. Except for count 16, all counts will run consecutive to one another. I am imposing consecutive sentences, finding that the consecutive prison terms are necessary to punish you and protect the public from future crime.
I mean, I'm out, man. That was it. I'm out.